Good afternoon, Commissioners. You'll recall we discussed back in the summer a court case which held that the names, addresses, and phone numbers of citizens on file.
And that wasn't a Maryland case, though.
That was a Maryland case.
It was a Maryland case. Okay.
The phone numbers, names, and addresses of citizens on file in a Prince George's County case were covered by the Public Information Act. I concluded from that that the term public records would include electronically stored versions of emails. And
did that case go before the Red Robes or what?
Yes, that was the Court of Appeals case.
But did it address email or not?
It didn't address email. It addresses people's home phone numbers, addresses that were on file.
When we send PIEs out, I thought you said that you take out addresses and phone numbers.
I take out addresses and phone numbers. I haven't been challenged on that yet, but in my opinion, the logical conclusion of that is the email addresses would be considered public information.
Oh, so would addresses and phone numbers then?
Yeah.
Do you know, are you aware of any
take those out.
Attorney General's opinion issued to anyone who's asked for it on this matter or anything close to it?
There are Attorney General opinions which hold that public records include electronically stored versions of email messages. The specific question of email list has not, to my knowledge, been the subject of a public document from the Attorney General's office.
Tim, where that's the position that the Governor's office took, would that be an appropriate question for us to raise to say, well, in this particular case, that's the position that's been taken. We'd like the Attorney General to weigh in on that.
And asking for an Attorney General's...
There's nothing wrong with the Commissioners asking for an Attorney General opinion as to whether email lists would be considered public information under the public...
Well, just email addresses of any sort.
I mean, there would be no reason, logical or legal, that if there was a reason why the Governor could exclude that we wouldn't be able to as well, is there?
I mean, if applicable to you, it should be applicable to the Governor's office, yes.
But in terms of this threat to public, what is it, public interest, and a couple of other phrases that were used that were equally dramatic, it seems to me it would be either one thing or the other.
Well, what the Governor's office did, from what I understand, is that they cited not a provision of the Public Information Act, they cited the general catch-all provision saying this would be, there are no exceptions to the Public Information Act that would govern this, but this would be, quote, contrary to the public interest. For us,
substantial injury to the public interest.
Yeah.
It probably would have been better if they had gone ahead and petitioned the court for a ruling on it.
Well, the tactic that was used was the citizen was advised that, from what I understand, that they were not going to release the emails, and that the Governor's office then said, well, we'll go to court in 10 days if you want, and we'll get a court order that allows us to do this. And apparently it never went that far if the citizen withdrew their request.
Right.
So we never got a determination as to that.
Now, if that had happened, would that serve as legal precedence for us to follow the same course?
Yes. If I had a legal opinion or a part of the statute that allowed us to do this, by all means, that would be that would be the precedent we need.
That's why I said it would have been better if it had played itself out in court.
I've got a problem here with that's what I see as a bifurcated standard here. We're redacting. There's been no questions raised in the year we've been in office about the appropriateness of redacting names, addresses, and phone numbers. Or at least addresses and phone numbers. Okay, and the potential to do mischief and harm and inflict harm on someone is astronomically higher.
I agree.
With an email address than with a phone number. So it seems to be using the same standard of practice that we've been using to redact phone numbers. If we apply that same standard, the decision to redact an email address is a no-brainer.
I agree.
Well, perhaps it would be appropriate to seek an Attorney General's opinion in light of the Office of the Governor's refusal to...
It would be a general inquiry as to whether email address list would be considered public information under the Public Information Act.
Now, what's the difference between an Attorney General's opinion? I mean, certainly that doesn't have the same weight as a court decision.
That's right.
That's right.
So, is it just one person's opinion? Does it have some strength beyond that?
The Attorney General's opinion is influential, and you can even cite it in a court case as legal weight for an opinion that you
But
take.
the judge is the final word in these
The judge
things.
is the final word, yes.
Always, okay. I mean, is that something that we want to pursue? I mean, it seems like, I mean, in a matter of trying to get some measure of consistency, and something that really has just heretofore gone, it looks like determined, you know, certainly that would be not a bad place to start.
Well, I think we have enough precedent here, not only in these documents I reviewed with the board, but also in terms of the fact we're already applying a standard of care that I don't know that we need to go all the way up to the AG. I think that we should use our discretionary authorities within the county to redact these emails. If someone decides they want to test it, we certainly have enough documentation and evidence that it was not an unreasonable thing to do. It was done without without malice. It was not done with any intent to circumvent public information laws. I think we should simply adopt it as a policy, and if it gets challenged, it gets challenged. We'll provide our documentation, and we'll take it from there. Understand, to ask the AG about a hypothetical situation doesn't take into effect specifics surrounding any particular instance. It could be in the case of a full hearing, a court could decide in one case that redaction was appropriate, in another case it wasn't. I don't think going through this hypothetical process of getting another opinion from the AG is necessarily going to resolve it. And I think in light of the fact we have a standard of practice already that we've been using for phone numbers, I think we should simply extend that standard practice to email addresses. I don't think we should go any further.
Well, would it be hypothetical? I mean, we've had a PIA where we did release email addresses. Would it be hypothetical, or couldn't we use that as the example to get a ruling on?
The ruling would be, can we have just a general ruling as to whether Public Information Act, address list, email address list, or public information? That would be the simple question to be addressed by the Attorney General.
I mean, it's kind of strange that it has never come up, isn't it? I mean, in other jurisdictions.
No, it's come up in there, and it's come up under
Other
the...
jurisdictions just don't release them, so probably.
Well, apparently, it's come up in Prince George's County, because
Yeah.
we do have a court case.
Which went to the
Dealt
Court
with
of
home
Appeals.
addresses and phone numbers,
Oh, okay, that wasn't specifically...
Not
It
email.
wasn't email.
not emails.
Do we know what other jurisdictions' policies are?
Informal conversations with other folks were that the consensus was that these were public information. And-
They were public
Yeah.
information.
I mean, we've got this bill analysis of House Bill 228. It says makes confidential the name, address, telephone number, and email address of a member or enrollee of a senior citizen center. I don't really see what the difference is whether an individual is a senior citizen or whether they're a regular, or just a non-senior citizen. That this is under the PI. This is under the Maryland Public Information Act manual. It's identifying it as a piece of confidential information.
Well, ironically, the home addresses and phone numbers of public employees are listed as a specific exemption under the Public Information Act, in the Act, and that's another exemption they
employees.
carved out. There is no exemption carved out in general for email list of citizens made during inquiries to public officers. So unless I can point to an exception, I can't deny it, in my opinion.
Or you've been denying it for phone numbers.
I have been denying it for
Yeah,
phone.
So what's the difference?
And addresses, so I think the email, it would be it's much more of a risk to a citizen for someone to have your email than it is for them to have your address. They can look your address up in the phone book or on the web.
Records.
When did that-
Records.
When did
And
that
your
case...
phone number too, but your email, you can be attacked for your email address. You can lose important information. I think the email is that we should redact it just like we do
Was in
phone
the-
numbers and addresses.
I'm sorry, 2000, I believe it's 2003.
2003.
And I would add, Maryland is a Public Information Act friendly state. I mean, they err on the side of disclosure.
Well, there's nothing unfriendly about that. We're not talking about the content of the information. I mean, theoretically, the people want to know what you said to and from each other. If they want someone's email, then
Yeah.
it has to make you wonder.
The only reason to have the email is to engage in mischief, quite frankly. If they want the content of the email, get it. But to suggest that a third party that may be politically motivated should have access to email addresses. They may be published in an open forum, as we know has already been done in this county. We have to weigh the interest of our citizens, and the public interest isn't just in what can they get, but also in terms of not chilling communications.
Right.
I've had several people who are very angry that their email addresses were released.
Yeah.
And suffice it to say, I think it's not unreasonable to argue that if they know they're going to be released, it's going to have a chilling effect under which probably the number one communications media that citizens like to use, which is electronic mail systems.
What would be the downside of us getting an opinion, though?
Nothing.
I guess the downside might be that he tells us something we don't want to hear.
Well, but he's going to tell the governor the same thing.
That's right, and then I'm going to ask the governor for his list.
There you go.
And everybody else who has the list by
There's an assumption here. We live in look, I'm not going to impinge either political party here, but a neutral comment is the bottom line is there's an assumption that the answer that a friendly political party will get would be the same as the interest that perhaps a hostile political party might get asking the same question. And I'm not prepared to concede that those answers would be the same. But people know which side their bread is buttered on. And the answer that John gets might be different from the answer that Mary gets if they belong to different political
Then
parties.
you should ask the question according to this one.
What if that was the hypothetical?
Yeah.
I'm sorry.
You cite the governor's opinion
was the
as an
hypothetical?
example.
I don't know that we can do that if we weren't parties to the opinion.
Well, what we say, give us opinion on this practice of withholding email addresses in light of the governor's office's, opinion along those lines. We could do that, couldn't we?
Yes, you could.
I mean, we need some example. It would just be a matter of picking some example to use.
There have been no published opinions on that from the Attorney General. It could merely be a request for an opinion as to whether these should be published.
Let me ask you this. When I get engaged in contract issues and legal work, one of the things I ask is what's the worst can happen? You don't want to, there's a saying, don't run in front of steamrollers to pick up nickels. In light of the fact we have all this documentation here showing that it's reasonable and there is no formal opinion on this, what's the worst can happen if we take the more conservative position and say we're not going to release them? What's the worst can happen?
We would have to go to court to file for an opinion from the court.
And the court renders an opinion.
For their fees,
And the court renders an opinion, and they either say release them or they say don't release them, right? That means somebody has to sue us.
Yeah.
You might want a name.
I personally agree, but that's not what the case law says. I mean, isn't that what you're telling us?
If someone's home address and phone number must be disclosed under the Public Information Act, as that Coors case said, and granted, I've taken some liberties with that. Why shouldn't their email address be disclosable?
Yeah, but we're not even following that case law ourselves. We are redacting the addresses and the phone numbers. So
But I'm not sure
I
that-
don't understand that argument at all.
No, but I'm just
We're not even paying attention to that. So why would we not only begin to pay attention to that, but now add emails to it?
Well, I
What kind of
guess,
argument is that?
I guess the issue is if we're going to not disclose one, we shouldn't disclose the other, but if we have to disclose one, we have to disclose both.
Well, I think that's the thing. I don't think an adequate defense for us would be that we're not disclosing the other. I don't think that's... that would hold up either, necessarily, but I'm no attorney.
That was an interesting discussion, and obviously one that has no easy answers, I would say. I haven't seen the documents that Mr. Rothschild presented, so I really can't speak to what those precedents are that he's referencing. The agenda wasn't really clear. That the weekly agenda that you put out, it said that there was going to be a discussion of emails being released, not email addresses. And I really, to be honest, don't care so much about that. I'm more concerned about the emails that are going back and forth between yourselves and outside of the county with others where policy is being discussed or enacted. For example, the hiring of a lobbyist. Was that all discussed in open meetings, or I'm being rhetorical here. Was it all discussed at open meetings, or was some of it done by email? And if so, that, that might be a discussion for another day. But while I'm here, as long as Ms. Fuller's here, I would like to ask the question, maybe you can help me understand what brought this all up. What happened to make people angry about, and what, with the emails being released, what was the circumstance that got people?
I'm going to answer that, Ms. Grady. It's a reasonable question. First, I want to say I agree with you. The communications between this Board of Commissioners and each other and third parties should absolutely be available through PIA. I agree with you 100%. I know I don't agree on a whole lot, but I agree with you on that. And number two, I did receive some verbal complaints from citizens whose email addresses were released and subsequently posted on a website.
Oh, okay. Well, I'm not privy.
I think your other question was, in what context? A person making a PIA request specifically asked for the email addresses of all the people that had been communicated to on some issue. It was something that had that was a specific issue, and that happened. Those email address parts at the top of they weren't blacked out, and so the effect was that the number of people that were on those various emails had their email addresses go to and that was a piece of information specifically requested because initially the content of the email was forwarded to the requester without it, and they came back and demanded that the email addresses be included. I think that was the sequence of events. It's been a while.
As I said, there are no easy answers.
Yeah, well, that's kind of what we're reacting to.
Ms. Grady, I hope you can agree that this really provides protection to all citizens, regardless of their political affiliation.
Well, I'm not privileged to all the details, and I think I know the PIA request that you're referring to, but didn't it have something to do with you and Ms. Fuller conducting business relative to some politicking or something out-of-county activities, your speaking engagements, that sort of thing, using county resources for that?
I don't get speak. I can say that everything that Ms. Fuller and I have done is completely legal, ethical, and appropriate.
But wasn't that what prompted some of those emails having to do with that Public Information Act request?
There have been multiple issues raised with me.
Okay. But relative to your conducting, using county resources to conduct non-county related business?
I've never used county resources.
Relative to setting up speaking engagements and doing other things outside the county that really don't have anything to do with county business, using county resources? Is that what prompted it?
Let me know you're done, and then I'll respond after you sit down.
Okay, I'm done.
Okay. All right. Do you really want to respond, or we?
Yeah, I do want to respond.
Okay.
Are you finished, Ms. Grady?
For the moment.
Why do you want to respond?
I do want to respond. Because Ms. Grady has made an assertion which is simply not true. So I want to make sure I make it very clear that Ms. Fuller and I have never used any county resources to conduct any non-governmental business, period.
Okay. I move we adjourn. Are we finished?
I'll second that.
That was not an assertion, by the way, it was a question.
All in favor?
Aye.
All right.